Okay, let's bring the court back to order, please. I have no action from executive session unless some of you do.
Judge, I'd like to make a motion based on the team letters that were sent out to Ed Chance and Linda Brazil, or the demand letters. I'd like the court to vote to rescind these demand letters until damages have been proven against Alliance Construction or Development. And I move.
Is there a second to that motion? Is there a second for that motion? Motion dies for lack of a second. Okay, do we have any citizens that would like to address the court today? Bill?
It only happened like a bolt of lightning. It happened over a long period of time. A lot of crossroads and forks in the road were approached and decisions were made. There was a decision made to have a special purpose entity. Why? There was a decision made to have certain people involved in it. Why? There was a procedure on all the bills, and I don't know what that is and how they came to be and how they came to be reviewed, and if an ordinate trust was given to Ms. Brazil. I don't know. I don't know why. I don't know what the final approval process was of the bills. I know ex officio that the members of the court all sat on the special purpose entity. So at the same time that that was happening, it was happening to you, and people were missing things. There was a reason to go to a developer rather than do it through it. I think at the time it was purchasing. Why? I think we need all of those answers. I think we need these answers, and it has to be done is through some sort of an open forum or an open inquiry and a report written and testimony taken under oath. I said this 11 months ago, and I say it again. We still don't have those answers, and this is $12 million. And I remember getting involved in the fight on the contract, and that contract may be a big detriment to what you're doing relative to her. And it's just, I think it's something that you have to do, and I would appreciate if you would do it, and we could find out exactly what happened, if it's painful, it's painful, but I think it's something that has to get done. Thank you.
Are there any other citizen comments today? Steve?
Thanks, Judge, Commissioners. This past year in the 83rd legislative session, there were two issues that came up on a pretty regular basis. One was the egregious behavior on the part of the federal government towards our Fourth Amendment rights, and the issue of transparency came up over and over again. And more recently, at the state level, we've had an issue with a university commissioner member that and I don't want to name the school, it's not important, but he brought up some egregious behavior on the part of one of the other members. And rather than opening up a full investigation, it actually led to one of the state lawmakers not running again. And rather than throwing transparency and showing transparency on this action, they took the Ethics Commission and they turned it on him. And I really believe that there's we have some problems right now with the state, with people trusting its government. And it's not a result of anything that y'all have done. I don't believe that for a second. I'm not shining a spotlight on you and saying that you've done anything wrong. I'm simply saying this is the attitude from the federal government and the state government towards some of the things that have happened at the federal and state level. And I just want to tell you how much I respect you guys, and I appreciate the fact that you're looking into this, and I ask that you'd keep it open and transparent and you get to the bottom of it. So thank you very much. Appreciate it.
Thank you, Steve. Thanks, Steve. Next. Is there any other citizens' comment?
Judge, before we move on, Commissioners and Judge, I believe we made the right decision back in November to give J.D. Lambright's office the authority to move forward with these issues. And I'd like to thank J.D. for taking the action that he felt was appropriate, and I think it was equally as important that this court reaffirm that decision here today. And so I sincerely thank you for that. And also, I think this court in this county owes a great deal of gratitude to Mark Bosma for being the one who took the time and energy to go through stacks and stacks of paperwork and to be able to identify and put together the puzzle of just how all this happened. And as some members of court have mentioned, or some members in the audience, that doesn't really, over time we'll be able to find out exactly why and how things happened that they did, but I don't believe that this court, as a governing body, had any ill intent. I think that the actions always were meant to improve this county and do the best that we can for Montgomery County, and I just wanted to say that.
Okay. Next, Human Resources. All in favor, say aye.
Kind of run down what has all transpired on the Corley unit and what brought this on.
Well, as you know, the Joe Corley Detention Center, which is separate and distinct from our Montgomery County Jail, sometimes those get confused. It's a federal detention center that was owned, by a county entity here. That sale has been completed. It was sold some months ago. We do still own the Montgomery County Mental Health Facility, and there have been ongoing negotiations about a potential sale of that, but that sale has not been consummated on that. And just one extremely common misunderstanding on the mental health treatment facility, that is not a facility that treats mental health patients here in Montgomery County. That treats individuals from all over the state who have been brought here in custody, and a judge somewhere has deemed them to be incompetent to stand trial. So they're facing either felony or misdemeanor criminal charges, and they're sent to our mental health treatment facility to hopefully regain their competence sufficient to stand trial. When that occurs, then they're transported back to wherever they came from around the state to take care of their criminal business there. There was an ongoing criminal investigation that the U.S. Attorney's Office, FBI, and so forth was in looking at any possible criminal activity associated with the construction and so forth of both of those facilities. And I do know that the feds had asked our local district attorney's office to stand down, if you will, let them complete their investigation. Well, the feds then completed theirs and then didn't take any further action and handed it off to our local district attorney, and they conducted an exhaustive investigation over a number of months. And that was all presented to a grand jury, and Brett Ligon, our district attorney, made a presentation in Commissioner's Court back in April of this year. So there were no indictments that came out of the grand jury proceedings, but as you well know, in a pretty unusual move, the foreman of the grand jury came forward and actually read a letter on behalf of the grand jurors to the entire Commissioner's Court at that time. That was also back in April. So once that criminal investigation, that ended at that time, and then we started looking at it, and of course Mr. Bosma is one individual we talked to, but we've talked to anyone we thought was appropriate to get information from. We've reviewed all the documents that we could get our hands on, and I'll say the DA cooperated fully in that in our investigation, but his hands are tied in one rather large way, that a lot of what the DA gained was acquired via a grand jury subpoena. And grand juries, as you know, are secret proceedings, and so he cannot, by law, give us documents that were acquired via grand jury subpoena or make us privy to testimony that was done before a grand jury. But he did turn over everything else that was acquired outside of that proceeding, which was a fair amount of information. So what we have done now is looking at it on the civil side, which is a completely different case, a completely different burden threshold. You don't have the criminal intent that is required in a criminal case. You've got to intend to do something wrong in most criminal proceedings, but you don't have that on the civil side, which is what we're looking at. So we have spent in my office a number of months now. We put together a staff just to look at various aspects of this, gather the data, talk to individuals. And we presented our preliminary findings back on November 4th to Commissioners Court. And coming out of that was the resolution they issued on that same day, giving us the full and complete authority to pursue any and all claims involving the construction of those two facilities, up to including litigation if that becomes necessary. And that resolution didn't name any specific individuals or anything like that. We had the full and complete authority to complete our investigation and move forward, which is, as is now known publicly, that's what we did. We sent demand letters out to 3 different individuals that we think played a key role in the construction of those facilities. And they've had those demand letters now for, I guess, a week and a half or something like that. Our hope was that would prompt some discussion, a dialogue, if you will, that we would get contacted by either, the lawyers representing one or those individuals or those individuals themselves, and we could learn perhaps new things. They bring new material to light that we don't know about. But anyway, open a dialogue that maybe there's a way to settle this thing pre-lawsuit, and that's what we had hoped to do by sending those demand letters.
Now, you've got allegations of 3 different, 3 individuals or companies, what do you call it? Alliance is the first one. What brought this on? What brought the Alliance factor up? The dollar figure, where'd you find as far as you're naming some dollar figures here?
Well,
$12 million.
Alliance was the, quote, the developer in the project, which is a fairly unusual player in terms of county government. Alliance didn't furnish the land. They didn't finance the construction. They didn't build the buildings. They didn't have any kind of financial role like that in the case.
First of all, your name?
B.D. Griffin.
Okay, you with the county attorney's office.
I'm
also.
Assistant County Attorney. I'm Chief of the Real Property Division,
Okay, tell
County
me,
Attorney's Office.
take the letter here. What Alliance? How are they involved? Or at what point are they involved?
Well, Alliance was the developer on both projects. Was the contract, had a contract with the county to build both projects. And that was their involvement in the project at this point.
Okay, dollar-wise, how did they come up with the dollar? How did y'all determine this dollars?
Sure.
And what dollar amount?
Sure. In analyzing these types of cases, we took the value of the property of the building, the cost of construction, as represented by Alliance in the construction documents, and compared it with the value of the property as built with regard to both materials and also any changes in scope of work. And there was what we felt was a significant difference between the value of the properties as represented and the values of the properties as built. And in subtracting those 2 figures, that's what we came up with in the damages. We took the value of the property as represented on a cost basis based upon both the appraisals, independent appraisals, which the county has obtained for those buildings, and we came up with damages slightly over $12 million for the 2 facilities that Alliance was the developer on.
Now, the dollar figure, you're looking like one remark in there. There's as far as the mental health facility, as far as number of beds, it was called for so many beds. Then I believe it was what state law changed that, or jail commission changed that a little bit.
It was a change.
Dropped down, but the dollar figure never changed.
It was a change in the scope of work and the specifications regarding the scope of work. Initially, Alliance's proposal was based upon 100 resident beds and 8 infirmary beds, as well as the security being up to jail commission standards. After the qualifications were presented, they were picked as the design builder, developer. In conversations with the state, those specifications changed where it's a mental hospital standard, and the beds went from 108 in the infirmary to 94 beds plus 6 in the infirmary. So it went from basically 108 bed facility to about 100 bed facility. And so that necessarily causes a difference in changing what we thought we were getting as opposed to what we actually got.
But the contractor never got it, but Alliance did get it. As far as the money that was, I mean, I don't word this wrong. The contractor never was paid for the additional beds that were to be put in, which never put in, but Alliance was paid for that. All right?
Essentially, the contractor, there's a change order in the contractor's contract where the contractor received approximately $2 million less for the construction, and that savings was not passed along to the county by the developer.
The second one, you've got Ed Chance, former Commissioner Ed Chance. How does he play a part of this?
Well, Commissioner Chance was commissioner, oversaw the project as commissioner, took special interest in the project. We believe he had a fiduciary duty in acting as almost a project manager on this project for the county, and felt he breached that duty as basically allowing Alliance to overcharge on the project.
The $500,000, how do they come up with that with him? Or how did he benefit financially, or how?
Based upon the information we had available, which, as JD said, we don't necessarily have all the information available. Based upon the information available, that was what we considered to be the improper benefit that he may have received as a result of the breach of fiduciary duty.
Okay. And third one, Linda Brazil. She was kind of acting as a go-between.
Ms. Brazil was a consultant on the project. Had been a former county auditor for many, many years. Along with Commissioner Chance, we believe Commissioner's Court placed a high degree of trust in Ms. Brazil, and which created a fiduciary duty on her part in overseeing the accounting and this project. And you know, for whatever reason, she didn't live up to those duties.
No, they're saying a little over $2 million on her. Was that all she was paid during that time, or is it quite a bit more?
No, it's not $2 million.
I'm sorry,
I'm sorry,
200,000, I think it was. I'm sorry.
242,000, yes. That was determined by the entry. She was paid on an hourly basis by the county during her time as a consultant, and that figure was taken from her time sheets based upon what she showed as the time she worked on those two construction projects only, not anything else she did for the county, and not for anything she did on those projects that was not construction related.